Hello, everyone, and welcome to Uncivil Law. For today's case, we have a situation where a teenage boy was out playing with a toy gun. The toy gun in question looked very realistic, and as a result, the police confronted him and then shot him several times. So, we're here to discuss whether there was an excess force or whether or not this was proper. So, we're going to look at the facts of Patricia Nelson and the city of Battle Creek. So, let's get started with this case. In 2013, NK, a minor, and his friends were playing cops and robbers around his neighborhood. NK carried around his airsoft BB gun to make the game feel more real. This toy handgun was all black and was missing its blade's orange barrel, which typically indicates a toy gun. I only fence sit when I should, I don't know. I normally have pretty strong opinions. In fact, I was chided by the Vic people for having a strong opinion. Like I have a strong opinion, but then also I do legal commentary rather than policy. So if I have a strong opinion as to legal, I'll give you a strong opinion if I think the court is wrong or not. But like in the last case we covered, it's like I certainly said I expressed my doubts about certain things where I thought it was doubtful, or in the other case where I thought things were questionable. But yeah, it's like, do I think it's good as a matter of policy? No, but I don't discuss policy on my channel. I discuss law. If I discuss policy, then I would be Tim Pool, or the quartering, or insert your own thing, because that's what they do. Is they do policy, right? I do law, so I try to keep the policy views to a minimum. Meanwhile, a Battle Creek dispatcher reported that a white male was carrying a black gun near a party store. At near noon, Riviere responded to the dispatch call and drove to the party store. Riviere approached in his patrol car. NK emerged from behind a sign and walked toward his friends by the storefront, carrying this fake gun. Riviere stopped NK and his friends, immediately exited his patrol car, shouted, "Let me see your hands, let me see your hands." So just bad timing all around. He's responding to a call, from a report about a black handgun, and he runs into someone who apparently is carrying a black handgun. Bad timing. Tamira Rice? I don't know. Who's Tamira Rice? Should I know that name? Oh, the shooting for that one playing with the toy gun. Yeah, I mean it would be similar in that case. I look based on the fact. Quick, sure, so it looks similar. While both parties agree that's what occurred within the 2 second time span, they disagree about the exact sequence of each act. NK's view of the facts is that he dropped the gun before Riviere shot him. In Riviere's view, he made the decision to shoot while NK was still gripping and raising the gun. According to Riviere, it was only after he decided to shoot and started pulling the trigger that he realized NK was tossing the gun away. Importantly, for the purposes of appeal, Riviere has conceded that at the moment the bullet actually hit him, NK had thrown away the gun and been raised and stored to raise his hands. In 2016, Nelson sued Riviere under 1983. He alleged a violation of Fourth Amendment right to be free from excessive force. We reviewed de novo a district court's denial of summary judgment motion based on the qualified immunity. While there is video record of the incident, we take the facts that appear in the video, which may not necessarily be in the light most favorable to the non-moving party. Any remaining gaps or ambiguities in the facts as recorded in the video, however, are to be viewed in the light most favorable to the non-moving party. Police officers are immune from civil liability unless, in the course of performing their discretionary functions, they violate a clearly established constitutional right. Qualified immunity allows for police officers to have breathing room to make reasonable but mistaken judgments and protects all but plainly incompetent or those who knowingly violate the law. So we are well familiar with the qualified immunity standard on this channel. We discuss it quite a lot, and as we learned from many, many cases, it goes quite a long way. Whether or not it should or not is more of an issue of policy. I have my serious doubts. It's whether or not it should go as far as it does, but let's continue on. In cases involving the use of excessive force, the qualified immunity question should be analyzed under the Fourth Amendment and the reasonableness standard. The district court denied the motion for summary judgment because it found the legal question as to whether or not it established a clearly established right turns on disputed facts and depends upon the view of which the facts the jury might accept. The material facts, however, can be gleaned from the parties' joint statement and a dash cam video. NK's own disposition testimony fills in any gaps, and Riviere has conceded to NK's version of the facts to the extent they do not contradict those of the video. The key disputed issue, according to the district court, are NK's compliance vis-a-vis the timing of the shooting and what movement NK made with his hands when Riviere ordered him to show his hands. But these are not genuinely disputed. NK acknowledged that, when given an order to raise his hands, he pulled out the BB gun out of his pants and began to raise his hands. Riviere, in turn, has conceded that, by the time he shot NK has released the gun and begun raising his hands. As explained below, the law was not so clearly established that every reasonable officer would know shooting NK under these circumstances would constitute excessive force. Qualified immunity therefore applies. So, yeah, another decision where a court finds qualified immunity for shooting someone who apparently was throwing a gun away, and the gun was thrown away by the time they were shot, and it wasn't really a gun in the first place anyway. So, another instance where where police, said, "Show me your hands," and 2 seconds later decided to shoot them, is a little bit, questionable, but it's not clearly established. So, qualified immunity is put in place. I have my doubts as to the reach of qualified immunity doctrine, but that's where we are. Okay. That would be an example of a place where I offer some policy issues. Also, where I say things like, I don't like Wickard, or I don't like Chevron. I wish these cases would be overturned. So occasionally I dip into policy, but not principally what I do. We therefore must inquire whether, as of 2013, it was clearly established that it was unconstitutional for an officer to shoot over the 2 seconds. Someone who pulls what appears to be a gun, drops it, and raises his hand after being given a warning. Well, if it's within 2 seconds, you didn't give a lot of chance for that warning to really take effect, did you? We hold it was not. Okay? Riviere reasonably responded to a threat of serious harm when he saw NK reach for and grab what looked like a gun. It was not objectively unreasonable for Riviere to decide to shoot NK as he saw him grip and raise his gun, even if the bullet ultimately struck NK after he dropped the gun. Again, you gave him no chance to respond because it all happened within 2 seconds. Show me your hands. Bang. It's, not really great. Neither the district court nor Nelson identifies any case law where an officer under similar circumstances have violated the Fourth Amendment. Well, how about just the idea that you might want to give them a chance to comply of some variety? Show me your hands should probably not be preceded immediately by firing without more. Even assuming that NK dropped the gun and was raising his hands before Riviere shot him, that does not alter our analysis. Okay. What matters is a reasonable officer's belief, and the fact that he was actually unarmed when shot is irrelevant to the reasonableness inquiry. That's what the court says, man. I'm just reading what they say, okay? Although hindsight reveals that NK was no longer a threat when shot, we do not think it's prudent to deny police officers qualified immunity in situations where they're faced with the threat of serious physical injury or death and must make a split-second decision. Indeed, the Supreme Court and Sixth Circuit have repeatedly held that an officer's employment of deadly force in split-second decisions should not be questioned. Thus, Nelson has not met the burden to demonstrate the contours of NK's right were sufficiently defined that every reasonable officer would understand the use of deadly force would violate the rights. So, again, it's like, I guess don't play with toy guns or something, because, if an officer sees you and shoot you, even though you're doing nothing wrong, it's not wrong for the police officer to shoot you either. So I guess don't play with toy guns or something. I don't know. This case before us is not an obvious case such that general principles of Garner, Graham, and Robinson, a reasonable officer would be aware it violated the rights. Therefore, we reverse the district court's denial of qualified immunity and remand for entry of summary judgment. So that is the end of our coverage of Patricia Nelson versus the City of Battle Creek. In this case, we learned that the district court did grant qualified immunity, but the Court of Appeals reverses. We learned that this person was playing with a toy gun. Show me your hands. Bang, bang. And, apparently that was completely okay, even though we didn't give them a chance to comply. So, I don't really think this is necessarily a great decision. It is a decision of the Sixth Circuit, and unfortunately, it's in compliance with the case law, because qualified immunity goes quite a long way. So that's the end of our coverage, and indeed the end of the case, since it's been entered for dismissal. So that is the end of this. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support, Until later, my friends, cheers and goodbye.